Business structures that may be registered as brokerage entities. A broker may choose from a variety of business entities, sole proprietorships, partnerships, both general and limited, limited liability partnerships, corporations, and limited liability companies may be registered as real estate brokers and/or real estate brokerage entities. Chapter 475.01, FS, defines the term broker to include any person who is a general partner, an officer, or a director of a partnership or corporation that acts as a real estate broker. All real estate brokerage entities must register with the DBPR. Registration includes the names of every licensed and unlicensed general partner of a real estate brokerage general partnership or limited partnership and every officer and director of a real estate brokerage corporation. Every member of a member-managed real estate brokerage limited liability company must also register. A person licensed as a sales associate or broker associate may not register as a general partner, a member of a member-managed real estate limited liability company, a manager of a manager-managed real estate limited liability company, an officer, or a director of a brokerage corporation. Each business structure has unique features. Sole proprietorships are the simplest form of business organization. However, many brokers choose instead a business structure that reduces personal liability. Brokers should consult with legal advisors and tax advisors and consider carefully the liabilities and tax consequences of the various types of business entities before making this important decision. See business entities. Business entities. Sole proprietorship. A sole proprietorship is a business owned by an individual. Sole proprietors are personally liable not only for their own actions but also for the actions of any employees acting within the scope of their employment. A sole proprietorship can be formed without filing with the Florida Department of State. Sole proprietor real estate brokerage. A real estate brokerage sole proprietorship exists when the broker is the only owner. It is easy to organize and flexible to operate. A sole proprietor who holds a current active and valid broker's license can operate a real estate brokerage business. The brokerage must register with the DBPR. The broker owner is entitled personally to all the profits. Sole proprietors are personally liable for the business losses as well as the debts and torts, negligent acts arising from breach of duty created by law, of broker associates, sales associates, and others working for the broker when acting within the scope of their duties as either independent contractors or employees. A sole proprietor risks personal assets if sued. Note: sole proprietorship at a glance. The broker is the only sole owner, is personally liable for business debts and torts, must register the sole proprietorship with the DBPR, and must register trade name, if applicable, with the DBPR. If the sole owner broker should die or for some other reason be unable to run the business, it is unlikely that the business would survive. A sole proprietorship may be dissolved by ceasing business activities and notifying the DBPR, or by expiration of the broker license, court order, or death of the owner. When a broker considers this form of business structure, it is important that the broker consult an attorney and a tax accountant to plan for how the business will continue to operate if the sole owner becomes incapacitated. Brokers may use their own name or a trade name. A broker who chooses to do business under the broker's own name simply needs to have an active broker license in good standing. The broker must register the business address with the DBPR by completing the appropriate form. If the broker wants to operate under a trade name, it too must be registered with the DBPR. A trade name is a business name other than the legal name of the person doing business. A brokerage entity may be registered and operate under no more than one trade name. Chapter 475, License Law, does not require a sole proprietor to register a trade name with the Florida Department of State. However, if another business entity has previously registered that name with the Department of State, the brokerage may not use the name. General partnership. A general partnership is an association of two or more persons organized for the purpose of jointly conducting a business. Each general partner has unlimited personal liability because each is responsible for all the debts incurred in conducting that business. Each has the power to bind the other or others in transactions, and each is entitled to receive a share of the profits in an amount agreed on by the parties. All general partners are joint and severally liable for damages resulting from lawsuits. General partners are agents for one another. If one partner enters into an agreement, the other partners are also bound to the agreement. Florida general partnerships are not subject to direct taxation. General partnerships feature pass-through treatment for federal income tax purposes. The partnership itself does not pay taxes. although it does file an information return, reporting the amount of income allocated, whether or not distributed to each partner. General partners are personally responsible for paying taxes on their share of earnings. A general partnership is created by a contract that may be written, oral, or implied from the conduct of the parties. Registration with the Florida Department of State DOS is voluntary. However, to conduct business, registration with DOS is prudent. To register, the partnership must submit to the Florida DOS a partnership registration statement and a statement of partnership authority. Internal Revenue Service IRS regulations require business entities that operate as a partnership to obtain an employer identification number. INs are used to identify business entities. General partnership, at a glance, 2 or more persons are involved. A general partnership is created by contract, written, oral, or implied. All partners are personally liable. Each partner is responsible for all partnership debts. Each partner can bind the other partners in contracts. Each partner shares in profits and losses as agreed upon. Real estate brokerage general partnerships. Brokers may choose to form a general partnership. Requirements regarding real estate brokerage general partnerships include the following. The partnership must register with the DBPR under the partnership name. To register a real estate brokerage general partnership, an application for real estate company license, DBPR Form RE7, is filed with the DBPR along with the required fee. Note: DBPR Form RE7 is a general form for all types of business structures. The partnership registration must be renewed every 2 years, on or before the applicable March 31st or September 30th. At least one partner must be licensed as an active Florida broker. The qualifying broker. The qualifying broker is the individual who should complete and sign the application. Section 3 of the application designates the name and license number of the qualifying broker. Active Florida brokers, inactive Florida brokers, and unlicensed individuals may be partners in a real estate brokerage partnership. The name, social security number, and address of unlicensed owners of the general partnership are listed on the application. All brokers who are general partners must be listed on the application. The broker's name, license number, and status, active or inactive, are entered on the form. The information is used to register the brokers and unlicensed partners. Partners who will deal with the public and perform services of real estate must be licensed as active brokers. Inactive brokers and unlicensed individuals may perform managerial functions for the brokerage general partnership that do not involve real estate functions, such as administrative matters, bookkeeping, and accounting duties. Sales associates and broker associates may not be general partners in a real estate brokerage partnership. Dissolution: a general partnership can be dissolved because of the death, withdrawal, bankruptcy, or legal disability of any of the general partners. It can also be continued after one of these occurrences, provided there is at least one general partner with an active broker license. It is wise to seek legal counsel before forming a general partnership, including assistance with forming a partnership and help drawing up a partnership agreement to address this issue. Trade name: if the partnership operates under a fictitious trade name, the name must be registered with the DBPR. Chapter 475, FS, does not require fictitious trade names to be registered with the Florida Department of State DOS. However, if another entity has previously registered the same trade name with a DOS, applying business entity may not use that same trade name when an application is submitted. The DBPR conducts a fictitious name search to verify whether another business entity is registered under that trade name. For additional information regarding registering trade names with the DOS, Division of Corporations, refer to trade names. Later in this unit, limited partnership. A limited partnership is created by a written instrument filed with the Florida Department of State DOS. There must be one or more general partners and one or more limited partners to qualify under the law. The limited partners have no managerial control. They make an investment of cash and/or of property, but not services. Limited partners are investors only. A Florida limited partnership is required by Florida statutes to file a certificate of limited partnership with the Florida DOS, Division of Corporations. The liability of the general partner, S, is nearly the same as in a general partnership. Limited partners are not liable to creditors of the partnership unless the limited partners' names appear in the partnership name, with certain exceptions, or the limited partners take part in the control of the business. Limited partners are liable only for any unpaid part of their pledged contribution, any assets of the partnership in their hands, and any distribution made to them while the limited partnership is insolvent. Limited partnership at a glance. At least one general partner and one limited partner are required. General partners are personally liable for business debts. Limited partners invest cash and/or property and may not participate in management. Limited partners have limited personal liability. A certificate of limited partnership must be filed with the Florida DOS. The partnership name must identify entity as a limited partnership. For example, limited or limited. The name of a limited partnership must contain the word limited or its abbreviation limited. A limited partner's surname cannot appear in the partnership name unless the surname is identical to that of a general partner or the business has been carried on with the name before the new limited partner's inclusion. If the name provisions are violated or if the limited partner takes part in managing the business, the limited partner becomes liable as a general partner. If the limited partnership operates under a fictitious name, the name must be registered with the Florida DOS. Division of Corporations. See also trade names in this unit. Real estate brokerage limited partnerships. Requirements regarding real estate brokerage limited partnerships include the following. The limited partnership must register with the DBPR under the limited partnership name. To register a real estate brokerage limited partnership, an application for real estate company license, DBPR Form RE7, is filed with the DBPR along with the required fee. The limited partnership registration must be renewed every 2 years on or before the applicable March 31st or September 30th. General partners may be active brokers, inactive brokers, and unlicensed persons. Inactive brokers and unlicensed individuals may perform managerial functions for the brokerage limited partnership that do not involve real estate functions, such as administrative matters, bookkeeping, and accounting duties. General partners who deal with the public and perform services of real estate must be licensed as active brokers. All general partners who expect to perform real estate brokerage services on behalf of the limited partnership must be licensed as active brokers. At least one general partner must be qualified and licensed as an active broker. All other general partners must register. Names and addresses are disclosed with the DBPR for identification purposes. Sales associates and broker associates may not be general partners in a real estate brokerage limited partnership. However, they may be limited partners. Limited partners are regarded in the same light as stockholders in a corporation. Limited partners are not required to register with the DBPR. Limited liability partnership at a glance. Limited liability for all. File limited liability partnership with the Florida DOS. Name must identify entity as a limited liability partnership. For example, limited liability partnership or LLP. The broker must register a brokerage limited liability partnership with the DBPR. All general partners with the DBPR and the trade name with the DBPR. Limited liability partnerships, LLPs. The partners in a limited liability partnership, LLP, enjoy protection from personal liability in much the same way as limited partners in a limited partnership. Limited liability partners are not liable for obligations or liabilities of the partnership arising from contract, errors or omissions, negligence, malpractice, or wrongful acts committed by another partner or by an employee, agent, or representative of the partnership. A limited liability partner is liable for any errors, omissions, negligence, malpractice, or wrongful acts committed by the partner, or any person under the partner's direct supervision and control in any activity in which the wrongful acts occurred, or for any debts for which the partner agreed in writing to be liable. The partners in a limited liability partnership are not subject to the limitations imposed on limited partners in a traditional limited partnership. Registered limited liability partnerships must file with the Florida DOS. According to Chapter 620, FS, the name of a registered limited liability partnership must include the words registered limited liability partnership or the abbreviation LLP, or the designation LLP as the last words or letters of its name. LLPs can register as real estate brokerage entities. Corporations. A corporation is a legal entity created by law and consists of one or more persons. The corporation is an artificial person considered to have an existence of its own, separate from the individuals. A corporation is formed by filing its articles of incorporation with the Florida DOS. The abbreviation Inc. is often used to mean an incorporated legal entity. A corporation has the legal capacity to make contracts and incur debts. It conducts its affairs under its articles of incorporation and its bylaws and must file its annual reports and fees with the Division of Corporations, Florida DOS. Foreign and domestic corporations. Both foreign and domestic corporations may register as brokerage entities. Domestic corporations are formed in the state in which it is doing business. In Florida, a domestic corporation is incorporated in Florida and does business in Florida. A foreign corporation is organized under the laws of another state or country and does business in Florida after it obtains a certificate of authority from the Florida DOS. Example: a person forms a corporation in the state of Delaware. The Delaware Corporation is a domestic corporation in Delaware. In the state of Florida, it is considered a foreign corporation doing business in Florida. In such a case, the person initially forms a Delaware corporation and then registers as a foreign entity in Florida as the same business. An individual considering operating a foreign corporation in Florida should refer to the Florida DOS's website for the requirements to qualify as a foreign corporation doing business in Florida. Corporations at a glance. Limited liability for all shareholders, directors, and officers file articles of incorporation with Florida Department of State. The corporation name must identify the entity as a corporation, such as corporation, corp, incorporated, Inc., company, or company exists perpetually. Shares of stock represent ownership. An annual report must be filed with the Division of Corporations, Florida Department of State. Characteristics. The corporate structure provides several unique features, including limited liability, centralized management, continuity of life, and transferability. Liabilities. A corporation incurs are obligations of the corporation, not of the individual owners, because the business is regarded as a separate entity. The security for any obligations the corporation undertakes is limited to the corporate assets. The owner's personal assets are not subject to seizure to satisfy corporate debts unless the individuals bind themselves as guarantors of corporate debts and liabilities. A corporation's stockholders, owners, elect a board of directors. The directors elect or appoint the officers of the corporation, usually consisting of a president, a vice president, a secretary, and a treasurer. The officers are responsible for managing the business operations. One individual may hold all the offices of a corporation, and in this situation, it would be a corporation of one. A corporation is considered to have perpetual existence. That is, an officer's or a director's death does not dissolve the company. A corporation files a dissolution of corporation with the DOS's Division of Corporations when it wants to end the business. Ownership in a corporation is transferred by the purchase and sale of stock. A corporation's profits and losses accrue to the company. It is taxed on its income under corporate tax rules. Corporations distribute dividends to their stockholders. Corporation losses may not be deducted by the stockholders. However, corporations may carry the losses forward and apply them to the corporation's future earnings. For-profit and not-for-profit corporations. A for-profit corporation is created to conduct business in the broadest sense of the term. In Florida, for-profit corporations are organized under Chapter 607. FSA not-for-profit corporation is created for religious, charitable, or educational purposes. Generally, not-for-profit corporations are formed under Chapter 617, FS, and organized substantially the same manner as corporations for profit. Chapter 475, FS does not make a distinction between profit and not-for-profit corporations. However, any broker considering forming a not-for-profit corporation should consult the Florida Department of Revenue and the IRS before proceeding. Real estate brokerage corporations in Florida. A corporation may be formed as a real estate brokerage firm after providing proof of legal corporate existence. Requirements regarding real estate brokerage corporations include the following. The corporation must register with the DBPR under the corporation name. Before submitting any paperwork to the DBPR, the corporation must first file articles of incorporation with the Florida Department of State. An existing corporation must be in good standing, meaning that the annual reports have been filed with the Division of Corporations. Refer to the web link on the next page to register a real estate brokerage corporation. An application for real estate company license, DBPR Form RE7, is filed with the DBPR, along with the required fee. If the brokerage corporation is going to operate under a trade name, that information is also entered on the application. The corporation registration must be renewed every 2 years. At least one of the officers or directors must be licensed as an active broker. The qualifying broker, active Florida brokers, inactive Florida brokers, and unlicensed people may serve as officers and directors of a real estate brokerage. However, officers and directors who will deal with the public and perform services of real estate must be licensed as active brokers. All officers and directors who are not licensed must be registered with the DBPR for identification purposes. This is accomplished by submitting each individual's name, residence address, office held, and percentage of ownership when completing the management information section of the brokerage corporation application. Inactive brokers and unlicensed individuals may perform managerial functions for the brokerage corporation that do not involve real estate functions, such as administrative matters, bookkeeping, and accounting duties. Sales associates and broker associates may not be an officer or director in a real estate brokerage corporation. A sales associate or broker associate may be issued a citation and fined for serving as an officer or director of a brokerage corporation. Sales associates and broker associates may be shareholders of a real estate brokerage corporation. The licenses of sales associates, broker associates, and individual brokers are registered under the brokerage corporation, not with any individual broker of the brokerage corporation. The DBPR visits the Division of Corporations website to check the names of the officers and directors of the corporation against the list of officers and directors on the registration application. The DBPR also verifies that the annual reports have been filed with the Florida Department of State. Before submitting the paperwork to the DBPR, it is prudent to check the public records either by the name of the corporation or the Federal Employer Identification Number, EIN, also known as FEI, to verify that the application is consistent with the public record. To perform a document search, go to www.sunbiz.org, search HTML, select Inquire by Name or Inquire by FEI Number. Case in point: a corporation purchased a commercial property. The corporation executed a sale contract. The vice president signed a promissory note to the seller and directly under her signature wrote Vice President and the corporation's name. When the note was not paid, an action was brought to hold the vice president personally liable for the debt. The trial court in the 4th District Court of Appeals held that the vice president could be held personally liable because she did not sign using the words as vice president for the corporation. Reference: Florida Realtor, Volume 72, Number 11, December, 1997, page 26. S corporations, typically real estate brokers who choose to incorporate or associated with closely held corporations owned by relatively few people, all or most of whom are involved directly in the corporation's business. As such, the businesses may qualify as S corporations. An eligible corporation can avoid double taxation by electing to be treated as an S corporation under the rules of Subchapter S of the Internal Revenue Code. In this way, the S corporation passes income, loss deductions, and credits to its stockholders, to be included on their separate returns. Furthermore, individual stockholders may benefit from a reduction in their taxable income during a corporation's first years, when it may operate at a loss. To qualify for S corporation status, a business must be a domestic corporation organized in the United States or originated under federal or state law. The business can issue only one class of stock. S corporations may have no more than 100 stockholders. A married couple count as a single shareholder without regard to how they hold their shares. The stockholders must be citizens or residents of the United States. Non-resident aliens cannot be stockholders. A corporation may become an S corporation by filing Form 2553, election by a small business corporation. A discussion with an accountant before incorporation is important in order to understand the deadlines, rules, and advantages of making an S corporation election with the IRS. Publication: IRS Form 2553 Instructions explains the tests required to elect to be an S corporation. Go to www.irs.gov Pub IRS PDF I 2553 PDF. Limited Liability Company. A limited liability company, LLC, is a business structure allowed by state statute. An LLC offers the best features of a corporation and a general partnership. It provides the owners protection from personal liability for business debts in the same way a corporation does. Income is taxed only once, as in a partnership, not double taxed. An LLC has great flexibility in how it passes income and deductions to its members. Limited liability companies are formed under Chapter 605. FS LLCs also have certain advantages over S corporations. For example, an S corporation cannot have more than 100 stockholders. However, there is no limit to the number of owners, known as members. In an LLC, both LLC members and S corporation stockholders may deduct business losses on their personal tax return. One disadvantage of LLCs is that the initial paperwork to set up an LLC is complex. Articles of organization or an application for authorization must be filed with the Florida DOS. Along with the filing fee, the name of the limited liability company must end with the words limited liability company or limited company. It is acceptable to use the abbreviation LLC. Also, the word limited may be abbreviated as limited, and the word company may be abbreviated as company. Limited liability companies can register as real estate brokerage entities. Brokers considering forming an LLC as a brokerage entity are cautioned to seek guidance from their legal consultants and tax consultants before proceeding. There are two general classifications of LLCs. Member-managed LLC. A member-managed LLC is run by the members, owners. Sales associates and broker associates cannot be members of a member-managed real estate brokerage LLC. Manager-managed LLC. A manager-managed LLC is not managed by the members. Instead, the members choose a manager to manage the LLC, similar to a director of a corporation. A member in a manager-managed LLC is an owner of the LLC, similar to a stockholder of a corporation. Sales associates and broker associates can be members, but not managers, of a manager-managed real estate brokerage LLC. Vacancy of office. If the only active broker of a brokerage entity dies, resigns, or is unexpectedly unable to remain in the position as active broker, the vacancy must be filled within 14 calendar days. The vacancy may be filled with a temporary broker. A temporary broker may be registered with the DBPR for up to 60 days without the need to comply with the Department of State DOS registration requirements. No later than 60 days after the DBPR registration of the temporary broker, the brokerage must file proof that a new broker is properly registered with the DOS. New brokerage business may not be performed by the brokerage or by a licensee registered with the brokerage until a new active broker or a temporary broker is appointed and registered with the DBPR. The appointment of a temporary broker applies to all business entities that may form a real estate brokerage entity. Failure to appoint another active or temporary broker within the 14-day deadline will result in the automatic cancellation of the brokerage registration, and the licenses of all people associated with the brokerage will become inactive. If the brokerage has more than one active broker and one of the brokers dies, resigns, or is unexpectedly unable to remain in the position as an active broker, the brokerage registration and the licenses of the broker associates and sales associates are not affected by the vacancy. It will be necessary to update the registrations with the Florida DOS and the DBPR to reflect the change in management of the entity. It is the responsibility of every active broker in a real estate brokerage to see that the brokerage and its partners, or officers and directors, sales associates, and broker associates have current and appropriate registrations and licenses. This is true of all types of real estate brokerage entities. Other business forms that may not register. Several business forms are not allowed to register as real estate brokerage entities. Corporation sole. A corporation sole is an ecclesiastical or church organization and should not be confused with a corporation for profit. It is normally headed by a bishop or other clerical official who has been empowered by a church to hold title to church property. The title descends to successors in office and not to heirs. A broker should exercise caution in dealing with a corporation sole. Before dealing with a corporation sole, a broker should obtain a written opinion from a lawyer who has experience in such titles. A corporation sole cannot be registered as a real estate brokerage entity. Joint venture. A joint venture, or joint adventure, is a temporary form of business arrangement often encountered in the real estate business. A joint venture structure is normally used when two or more parties combine their efforts to complete a single business transaction or a fixed number of business transactions. No written agreements are required to form a joint venture. The rights, duties, and obligations of joint venturers are similar to those of partners in a general partnership, except that they are restricted to the transaction for which the joint venture was formed. Real estate brokers often combine their efforts in real estate transactions to create a joint venture. A joint venture, when composed of separate real estate brokers, can broker real property. In such a case, the joint venture would not be required to register with the DBPR because each of the individuals is registered and licensed. If two parties form a joint venture to provide real estate services for compensation, both parties must be licensed real estate brokers. Business trust. A business trust is a form of business entity that may be created to engage in transactions involving its own real property. A business trust is formed by any number of persons who make an investment at a stipulated amount per unit. The monies collected in this manner are then used to buy, develop, and/or sell real estate. Title to real property acquired by a business trust is taken in the name of a trustee or group of trustees. Although brokerage activities take place within the trust, a business trust cannot be registered with the DBPR as a real estate brokerage entity. However, any employee who buys or sells real property for a trust and is compensated on a transaction basis must be licensed. Associations. Cooperative association. A cooperative association is permitted to conduct commercial business and to convey, sell, or buy its own property, but it cannot be registered as a real estate brokerage entity. Unincorporated association. Unincorporated associations are generally recognized as groups of people associated for some non-commercial common purpose. They are not regarded as partners and are not incorporated. An example is a group of property owners in a subdivision who organize for such purposes as beautification, planning, maintenance, or even the performance of services such as garbage removal. Such associations can incur liabilities, and members are responsible for debts to creditors in the same manner as partners. For example, each member is liable for all the debts, but as to each other, the members are liable only for their individual proportionate share. Unincorporated associations sometimes buy or sell their own real property through a trustee or board of trustees. A real estate broker should exercise the same caution in dealing with an unincorporated association as when dealing with a corporation sole. Unincorporated associations cannot be registered as real estate brokerage entities. Ostensible partnerships. An ostensible partnership, or quasi-partnership, is not intentionally created. Rather, the conduct of two or more persons creates the appearance that a partnership exists. It is considered fraudulent and deceitful if the public is led to believe that those with whom they are working are partners. In such a situation, the courts may consider that a partnership exists. Under the law, the parties can be held liable for each other's debts and towards wrongful acts. Real estate licensees who operate as ostensible partners may be subject to license suspension. Brokers sometimes do business in the same office building. This is permissible provided each broker displays their own office sign and uses separate telephone numbers. If such is the case, they cannot operate under the same name or use their joint names or the same trade name. Brokers should indicate their true statuses by using separate telephone listings, letterhead, business cards, and so forth. Advertisements reflecting that a properly registered broker is the franchisee do not fall under the definition of ostensible partnership. Trade names. A trade name, or fictitious name, is a business name other than the legal name of the person or a business entity. For example, if a broker is the sole proprietor and the broker operates under a name other than the broker's personal name, the broker is operating under a fictitious name. The DBPR uses the term trade name in rule and statute. Fictitious name refers to the name registered with the Florida DOS. The letters TA are used to indicate trading as. The letters DB are referred to doing business as. Sole proprietors and business entities may choose to operate under these designations. Registering a trade name with the DBPR. An individual broker or brokerage entity that desires to use a trade name must register the trade name with the DBPR. Before submitting a trade name registration to the DBPR, the broker should check the Florida DOS and DBPR records to confirm that the trade, fictitious, name is not already registered with either state department. The DBPR will not allow the broker or brokerage entity to register a trade name if the name has already been registered with either department. An individual broker or brokerage business entity may be registered under only one trade name. If a broker has several branch offices, all the offices must use the same trade name. Branch offices are additional locations of a real estate brokerage or sole proprietorship and must have the same name as the main location. License. The actual name of the individual or an entity is not a trade name. Sales associates and broker associates may not use a trade, fictitious, name. Sales associates and broker associates must register under their legal name. Example, a licensed real estate broker operating as a sole proprietor desires to operate as Fast Service Realty. The broker must register the trade name Fast Service Realty with the DBPR. To accomplish this, the broker submits Form DBPR RE12 to request to add a trade name. DBA. The broker discloses on the form his name as it appears on the broker license, real estate license number of the sole proprietor broker, and the trade name. Form DBPRRE12 is a form for real estate entity and sole proprietor brokerage changes. The form is used to add, change, or remove a trade name, to change the company name, change the company address, or to close the business. Fictitious Name Act. The Florida Fictitious Name Act defines fictitious name as any name under which a person transacts business in the state of Florida, other than the person's legal name. The Fictitious Name Act grants an exemption from the requirement to register a fictitious name with the DOS to a person licensed by the DBPR. Florida's real estate license law does not require brokers and brokerage entities to register their trade name, DBA, or fictitious name with the DOS. However, if another business entity with the same fictitious name has registered the name with the DOS, the DBPR will not allow the brokerage to register the same trade, fictitious, name when a brokerage corporation, limited partnership, limited liability company, or limited liability partnership registers the business entity with the DOS. It also satisfies the DOS fictitious name registration requirement for these types of business structures. General partnerships should either file with the DOS under the Partnership Act or the Fictitious Name Registration Act, depending on which statute best fits the brokerage entity's requirements. Recall the previous example concerning Fast Service Realty. The broker is operating as a sole proprietorship, so there is no requirement to register Fast Service Realty as a fictitious name with the DOS. However, the broker must register the trade name, Fast Service Realty, with the DBPR. The Division of Corporations maintains an index of fictitious names. To search the index, go to www.sunbiz.org, search HTML and click on the type of inquiry. Exemptions from filing under the Fictitious Name Act. Partnerships, corporations, or other legal entities that have filed or registered the business entity with the DOS and are in good standing with the DOS are considered to have met the requirements for fictitious name registration, provided they do not transact business under any other name. Additionally, if an owner's first and last names are included in the business name, the business is exempt from filing a fictitious name. Example: a real estate brokerage corporation desires to use the fictitious name Randolph Realty, Inc. The brokerage corporation must register the trade name with the DBPR. The DBPR will search the DOS list of corporations to make sure no other brokerage is using this trade name. The brokerage corporation must also file articles of incorporation with the Florida DOS. The filing of the corporation with the DOS also satisfies the requirement to file the fictitious name for the corporation. Example: Susan Brown is a real estate broker who wants to operate using the name Susan Brown's Real Estate Services. The broker is not required to register the business name as a fictitious name with the DOS because the owner's first and last names are in the business name. The broker, however, must register the trade name Susan Brown's Real Estate Services with the DBPR. Trade names: no person shall operate as a broker under a trade name without causing the trade name to be noted in the records of the commission and placed on his license, or so operate as a member of a partnership or as a corporation or as an officer or manager thereof, unless such partnership or corporation is the holder of a valid current registration. Reference: Section 475.42, FS. Forming a professional association in associates. Legal name: broker associates and sales associates may form a professional association so that their broker can pay commission to the professional association rather than to the individual licensee. Forming a professional association for income tax purposes, after consultation with a CPA or an attorney, should not be confused with forming a brokerage business entity to conduct real estate services. A broker associate or a sales associate may form a professional corporation, professional limited liability company, or limited liability company in the licensee's legal name. Recall that sales associates and broker associates must be registered and work under a broker or an owner-developer. A licensed sales associate or broker associate first registers with the DOS a professional corporation, PA, a limited liability company, LLC, or a professional limited liability company, PLLC, in the associate's legal name. The associate may then provide proof of the DOS registration and be issued, for a fee, a real estate license in the licensee's legal name, including the appropriate professional designation, to register the information with the DBPR. The licensee uses Form DBPR-RE16. At this point, the broker can pay the professional corporation or other allowable professional entity rather than the individual sales associate or broker associate. Example: a sales associate's legal name is Jane Doe. Jane could form a professional corporation and be issued a real estate license in the name Jane Doe, PA. Jane would be required to provide the DBPR proof of the creation of a professional corporation that is registered with the Florida DOS. Jane's broker could then make her commission checks payable to Jane Doe, PA. Section 475.161, FS, requires that such a professional entity must be made up of only one individual. Therefore, a married couple, both licensed real estate sales associates, would not be allowed to form a professional corporation. Each spouse would be required to form a separate professional corporation. Real estate office requirements. All active Florida real estate brokers are required to have an office and to register the office with the DBPR. A broker's office must consist of at least one enclosed room in a building of stationary construction that will provide privacy to conduct negotiations and closings of real estate transactions. A broker's primary office is called the principal office. The broker's books, records, and real estate transaction files are to be kept in the office. However, such items may be stored in an electronic format, which must be available at the office. Florida law does not require the broker to have a telephone, desk, business checking account, or an escrow account. If local zoning permits, the broker's office may be in the broker's residence, provided a required sign. See entrance signs in this unit, is displayed properly. If considering one's residence for a brokerage office, the broker should first consult applicable homeowners association rules or restrictive covenants and rules. Before selecting a brokerage office location, the broker should verify sign control regulations, see entrance signs in this unit, zoning restrictions, and inquire about city and county occupation licenses. The brokerage office must also comply with the Americans with Disabilities Act, ADA, and state law accessibility requirements. See Americans with Disabilities Act, ADA in this unit. Out-of-state brokerage offices. A broker may have the principal office or a branch office in another state. Before registering the out-of-state office with the DBPR, the broker must agree in writing to cooperate with the DBPR in the event an investigation is initiated under Chapter 475. FS. The broker also must promptly supply any documents requested by an authorized representative of the DBPR and personally appear at any designated office of the DBPR or other location in Florida or elsewhere as reasonably requested by the DBPR. For additional information, refer to Section 475.22, FS, Citation Authority 475.22, 1, and 61J2 to 10.022. Fail to maintain the required offices prescribed $500. Citation 475.22, 1, and 61J2 to 10.024. Fail to maintain the required office entrance sign $100. Citation 475.22, 2. Fail to register an out-of-state Florida broker's office $500. Citation 475.24, 61J2 to 8.003 and 61J2 to 10.023. Fail to register a location as a branch office $200. Citation reference, Rule 61J2 to 24.002. FAC. Broker associates and sales associates. Sales associates and broker associates cannot open offices of their own. They must be registered from and work out of either the principal office or a branch office maintained and registered in the name of their employer. The broker may appoint a broker associate or sales associate to manage a branch office. Branch office requirements. A broker who desires to conduct business from additional locations must register each additional location as a branch office and pay the appropriate registration fees. Thereafter, the broker must renew branch office registrations every 2 years. Branch office registrations. The Florida Real Estate Commission FREC may insist that a broker open and register a branch office whenever the FREC decides that the business conducted at a place other than the principal office is of such a nature that the public interest requires registration of a branch office. Further, any office will be considered a branch office if the advertising of a broker, who has a principal office elsewhere, is such that it leads the public to believe that the office of concern is owned or operated by the broker in question. Registrations issued to branch offices are not transferable. To illustrate, suppose a broker decides to close one branch office and open a new branch office at a different location. Even though these actions may take place at the same time, the registration of the closed office may not be transferred to another office. The new location must be registered and the fee paid. A broker may reopen a branch office in the same location during the same license period by requesting a reissue of the branch office license without paying an additional fee. Example: a branch office is closed because of major hurricane damage. The DBPR is notified that this office will be closed. The roof is replaced. other repairs are completed, and the office is to be reopened, the broker may request reissuance of the branch office license, provided the branch office license is within the same biennial renewal period. Temporary shelters. A temporary shelter in a subdivision being sold by a broker is not a branch office if the shelter is intended only for the protection of customers and sales associates. But if sales associates are permanently assigned there and sale transactions are closed there, the temporary structure must be registered as a branch office. The permanence, use, and character of activities customarily conducted at the office or shelter determine whether it must be registered. Entrance signs. Active real estate brokers must display an official sign on either the exterior or the interior of the entrance to their principal office and all branch offices. The DBPR does not regulate the size of the lettering on the entrance sign. However, the sign must be easily observed and read by anyone entering the office. The sign must contain the following information: trade name, if one is used, broker's name, the words licensed real estate broker or LIC. Real estate broker. Refer to the entrance sign. An example of an entrance sign of a sole proprietor using a trade name. The registered trade name is Littlemore Realty. The broker's name is Merle H. Crawford, and the required wording licensed real estate broker appears on the sign. The names of sales associates and broker associates are not required on the entrance sign. However, if the associates' names appear on the sign, they must be placed below the name of the broker, S, and the appropriate license type. Sales associate or broker associate must appear next to each associate's name. A line or observable space must separate the names of the real estate brokers from the names of the sales associates or broker associates. Example of an entrance sign of a sole proprietor using a trade name lists Carl Stauffer, broker associate on the sign, below a line that separates the name of the broker from the name of the associate. If the brokerage entity is a partnership, corporation, limited liability company, LLC, or limited liability partnership, LLP, the sign must contain the following information. See example of an entrance sign of a brokerage corporation, name of the firm or corporation, or trade name, if one is used. Name of at least one active broker, the words licensed real estate broker or LIC, real estate broker. Americans with Disabilities Act. ADA. The Americans with Disabilities Act. ADA is the federal statute that protects employment and accessibility rights of individuals with mental and physical disabilities. Access to public accommodations and commercial facilities. The ADA prohibits discrimination and ensures equal opportunity for persons with disabilities in employment, state and local government services, public accommodations, commercial facilities, and transportation. It also mandates the establishment of TDD telephone relay services. Public accommodations are facilities open to the public, including sales or rental establishments, hotels, restaurants, and shopping centers. Commercial facilities include office buildings, factories, and warehouses. Individuals with disabilities may not be denied access to public transportation, public accommodations, and commercial facilities. Real estate offices are considered both public accommodations and commercial facilities. Whether leasing or purchasing space, brokers must comply with federal and state laws regarding accessibility. New construction and renovation. Public accommodations and commercial facilities must be newly constructed or renovated, if readily achievable, to meet accessibility standards. Criteria for determining whether a public accommodation or a commercial facility can be made accessible is set forth in the Act. If readily achievable, structural, architectural, and communication barriers must be removed. Examples of alterations include widening doorways, making cuts in street curbs, lowering telephones, installing ramps, and providing ADA-compliant toilets and grab bars in restrooms. ADA requirements also apply to private entities that own, lease, or operate commercial facilities, including real estate brokerage offices, even if the broker's office is located in a private residence. Buyers who purchase older homes with plans to turn the structures into offices may face costly unanticipated expenses to modify or upgrade the facility to ADA standards. If the broker's office is in a private residence, the accessibility standards apply to that portion of the home used exclusively as an office and to those portions of the house available to customers, including bathrooms. Accessibility standards also extend to those elements used to enter the place of public accommodation, including the homeowner's front sidewalk, if any, the door or entryway, and hallways, and those portions of the residence, interior or exterior, available to or used by customers or clients. The accessibility standards do not apply to any portion of the home used exclusively as a personal residence. Employment practices. ADA governs employment practices regarding discrimination in hiring and reasonable accommodations in the workplace. Any alteration of an existing facility and all new public accommodations and commercial facilities must comply with the ADA's accessibility guidelines. When a broker leases commercial space, the lease agreement generally indicates who is responsible for the cost of any renovations required to comply with the ADA. Compliance includes removing barriers to walkways, parking lots, entrances, stairs, washrooms, water fountains, public telephones, elevators, electrical controls, and warning signals. The front door to every real estate office should be wide enough to accommodate a wheelchair. Sidewalks should have continuous common surfaces with no steps or sudden changes in level. A broker must install a ramp if needed to accommodate wheelchair access and must arrange room layouts to provide a place where people in wheelchairs can meet with sales associates. Accessible parking spaces must be marked clearly for use by disabled persons. Brokers must also incorporate the ADA requirements into their hiring practices. Brokers and associates hiring personal assistants must make reasonable accommodations to allow a disabled person to perform the duties required for the position. Florida Americans with Disabilities Accessibility Implementation Act. This Florida statute adopts the federal standards for accessibility for disabled persons. The intent of the Florida law is to incorporate into state law the accessibility requirements of the Americans with Disabilities Act of 1990, as amended, and to obtain and maintain U.S. Department of Justice certification of the Florida Accessibility Code for building construction as equivalent to federal standards for accessibility of buildings, structures, and facilities. All state laws, rules, standards, and codes governing facilities covered by the Americans with Disabilities Act standards for accessible design are maintained to assure certification of the state's construction standards and codes. Accessibility guidelines and specifications are available from local building inspectors and the Department of Justice. Local municipal or county governments are responsible for enforcing compliance with the codes. Before selecting an existing structure for a real estate office, a broker should contact a local building inspection department to request an inspection or hire a consultant to inspect the property to determine whether it complies with accessibility guidelines. To learn more about the ADA, visit www.ada.governor. Advertising and self-promotion. Anyone who advertises or claims to be providing real estate services is acting as a real estate broker. Therefore, under Florida law, advertising is considered a broker activity. All advertising must be in the name of the brokerage and under the supervision of the broker. Sales associates may not advertise real estate services in their own names. The broker is accountable for all advertising, regardless of who prepares the advertisement. Advertising includes brokerage entrance signs, letterhead, stationery and flyers, business cards, yard signs and billboards, newspaper and magazine ads, internet, radio and television, promotional materials, and so forth. Advertising key concepts. All advertisements must include the name of the brokerage firm. If a licensee inserts a personal name in the ad, the licensee's last name as registered with the DBPR must also be included. Licensees may use their nickname in combination with their last name on business cards and in advertisements. Advertisements containing the team or group name cannot appear in larger print than the name of the registered brokerage. Team advertising. It has become popular in recent years for associates within a brokerage firm to form a team. Team or group advertising is the name or logo used by one or more licensees who represent themselves to the public as a team or group. The concept of teams allows broker associates and sales associates to specialize in their area of expertise and to join forces to serve a wider group of customers more efficiently. Teams must perform licensed activities under the supervision of their registered broker. Each team must file with their employing broker a designated licensee to be responsible for ensuring that the advertising complies with Florida license law and administrative rules. At least monthly, the registered broker must maintain a current written record of each team's, groups, members. Real estate team names may include the word team or group as part of the name. Real estate team names may not include words in their name suggesting that the team or group is a separate real estate brokerage. See words that may not be used in team names. A team must advertise in the name of the brokerage firm. Advertisements containing the team or group name may not appear in larger print than the name of the registered brokerage. All advertising must be in a manner in which reasonable persons would know they are dealing with a team or group. The rule regarding team advertising applies to all forms of advertising. Blind advertisements. All advertising must be worded so that reasonable people will know that they are dealing with a real estate licensee. A licensee may not advertise real estate services in such a way as to mislead the public that the offer is being made by a private individual rather than a real estate licensee. Advertisements must clearly reveal the license name of the brokerage firm. Advertisements that fail to disclose the license name of the brokerage firm are blind advertisements. For example, an advertisement that provides only a post office box number, telephone number, and/or street address is a blind ad and is prohibited. Including personal information. A big part of a real estate associate's business is self-promotion, marketing the associate's services to the public. Licensees may insert their personal names in ads, provided they include their last name as registered with the DBPR. Licensees may indicate their nickname on business cards and in advertisements in combination with their last name, but they must be mindful that the advertising rule states that advertisements must not be misleading. Sales associates may indicate their cell phone number and/or address on their business cards, provided the card also includes the name of the brokerage firm. FREC does not require the inclusion of the brokerage firm's phone number or address in ads. If a broker, sales associates, and broker associates create promotional materials, such as refrigerator magnets, calendars, and notepads, they must include the license name of the brokerage firm on them. Yard signs are a form of advertising and, therefore, must include the name of the brokerage firm. Advertisements created by sales associates and broker associates must be supervised directly by their broker. Associates and their brokers should review advertisements for accuracy and also make certain the ad is canceled when, due to sale or listing expiration, the property is no longer on the market. False advertising. Publication of false or misleading information by means of radio, television, or written material for the purpose of inducing someone to buy, lease, rent, or acquire an interest in title to real property is illegal. If a sales associate or broker associate prepares a misleading ad, both the broker and the associate can be disciplined. Ultimately, a broker is responsible for an advertisement's quality, accuracy, and legality. All ads should be reviewed before publication, whether the company or individual associates submit and pay for them. Sale prices should be stated according to the terms authorized in the listing agreements. Brokers may not publish price information and price reductions without an owner's consent. It is important to avoid publishing any information that compromises the owner's negotiating position. All advertisements of real property must be accurate representations of the property. There is a difference between showcasing a property's features and misrepresenting the property. Truthful advertising is serious business. For example, it would be considered false and misleading advertising for a broker associate to use the title broker on the associate's business card. In Florida, it is a second-degree misdemeanor to publish false or misleading information for the purpose of inducing another person to buy, lease, rent, or acquire an interest in real estate. The real estate licensee also is subject to license suspension or revocation. Internet sites. When advertising on an internet site, the name of the brokerage firm must appear adjacent to or immediately above or below the point of contact information. Point of contact information refers to any means by which to contact the brokerage firm or individual licensees, including mailing address, S, physical street address, S, email address, S, telephone number, S, or facsimile, fax telephone number, S. Brokers should keep website information up to date by removing sold or expired listings. The broker should also keep sales associate information current by removing information regarding sales associates who have left the brokerage and adding information about new sales associates. Unauthorized use of association names. A licensee cannot use an association's name or an organization's designation unless the licensee is currently a member in good standing of the association. Dues are up to date. Active and inactive real estate licensees can be disciplined by FREC for false advertising for using the name or designation of an association, such as on business cards, to lead people to believe the licensee is a member of the association. Licensee selling property by owner. The rules regarding advertising real property do not prevent real estate licensees from selling their own property. Some brokers require that associates who own property they are selling to list the property with the brokerage. Real estate licensees who own property and are selling the property by owner may place their own classified advertisements. Licensees may include their personal contact information in the ads, such as the home phone number and street address of the property. It is not necessary for a licensee to indicate in the advertisement that the seller is a real estate licensee. However, because licensees have superior knowledge and expertise in real estate, to reduce liability, by-owner licensee sellers should disclose their license status before entering into meaningful, serious negotiations with the prospective buyer. Without such disclosure, the buyer may feel that the licensee has not negotiated in good faith. Disclosure of this fact should also be documented in the sale contract. Such disclosure is mandated in the National Association of Realtors, Registered Sign, Standards of Practice, NAR requires that member realtors, registered sign, who advertise unlisted real property for sale or lease in which they have an ownership interest disclose their status as owners, or landlords and as realtors, registered sign. Brokers should instruct their sales associates and broker associates who are considering selling their own property by owner to consult with the broker and review the office policy manual. Some brokers expect the licensee to list the property through the brokerage office. Rental information and lists. Some real estate brokerage firms offer prospective tenants a list of properties available for rent. However, very few brokerage firms sell this information. Rental companies or anyone who advertises rental property information or lists in any manner is acting as a broker or a broker's representative and is subject to the laws regulating licensed occupations. Receipt. Any real estate licensee who furnishes rental information to a prospective tenant for a fee must provide the prospective tenant with a receipt that contains a provision for repayment under specified conditions. The receipt must state that a prospective tenant who does not obtain a rental from the list is entitled to be repaid 75% of the fee paid if requested within 30 days of the contract receipt date. If the information provided to the prospective tenant is not current or is inaccurate in any material respect, the broker must repay 100% of the fee to the prospective tenant on demand. Any demand from the prospective tenant for the return of any part or all of the fee must be made within 30 days from the date the broker associate, or sales associate contracted to provide services. Such demands may be made orally or in writing. The contract or receipt agreement must follow FREC guidelines, and the broker must send a copy to the DBPR within 30 days of the first use. Criminal and administrative penalties for obsolete and inaccurate rental lists. Advertising rental property information or lists that are not current or are materially inaccurate is illegal. Any person who violates the requirements outlined earlier is guilty of a misdemeanor of the first degree and subject to a fine of up to $1,000 and/or imprisonment of up to 1 year. The administrative penalty for this violation is license suspension or revocation. Fair housing and advertising. The Fair Housing Act, as amended, prohibits discrimination in sales, leasing, the advertising of sales and rentals, financing, and brokerage services. Today, the Fair Housing Act includes 7 protected classes: race, color, religion, sex, handicap status, familial status, and national origin. No protection is given under the Fair Housing Act to individuals based on age, occupation, marital status, sexual orientation, or gender identity. However, fair housing laws passed by state and local governments may expand the classes afforded fair housing protection in their jurisdiction. The Fair Housing Act prohibits brokers from making, printing, and publishing advertisements that state a preference, limitation, or color discrimination on the basis of a protected class. The prohibition applies to publishers, such as newspapers and directories, as well as to persons and entities that place real estate advertisements. It also applies to advertisements where the underlying properties may be exempt from the Act's provisions, but where the advertisements themselves violate the Act. Race, color, national origin. Real estate advertisements should not include discriminatory preferences or limitations based on race, color, or national origin. Describing current or potential residents or neighborhoods in racial or ethnic terms, such as nice Italian neighborhood or no Caucasians, is prohibited. Religion advertisements should refrain from an explicit preference, limitation, or discrimination on the basis of religion, such as Jewish home or no Christians. Furthermore, licensees should not use references to religious landmarks when giving driving directions to properties in advertisements. Using landmarks such as a reference to a mosque, church, or synagogue may indicate a religious preference, which would be a violation of the Fair Housing Act. Advertisements that use the legal name of an entity that contains a religious reference, such as Trinity Presbyterian Home, do not violate the act if the ads include disclaimers, such as this home does not discriminate on the basis of race, color, religion, national origin, sex, handicap, or familial status. Sex advertisements for single-family dwellings or separate units in multifamily dwellings should not contain a preference, limitation, or discrimination based on sex. A phrase such as female roommate wanted is permissible only if it meets the requirements for shared living exception. According to the Office of Fair Housing and Equal Opportunity, terms such as master bedroom, mother-in-law suite, and bachelor apartment, commonly used as physical descriptions of housing units, do not violate the Act. Handicap real estate advertisements should not contain explicit exclusions or limitations based on handicap, such as no wheelchairs. Advertisements that describe the conduct required of residents, such as non-smoking, do not violate the Act. Advertisements may describe accessibility features, such as wheelchair ramp. Familial status. Familial status refers to the presence of one or more children under the age of 18 who live with either a parent or guardian. Familial status also includes a woman who is pregnant. In effect, it means that the Fair Housing Act's protections extend to families with minor children. Unless a property qualifies as housing for older persons, all properties must be made available to families with children under the same terms and conditions as to anyone else. It is illegal to advertise properties as being for adults only or to indicate a preference for a certain number of children. The number of persons permitted to reside in a property must be based on objective factors such as sanitation or safety. Landlords cannot restrict the number of occupants to eliminate families with children. Housing for older persons. Certain housing for older persons is exempt from the familial status protection under the Fair Housing Act, provided that all units are occupied by persons 62 years of age or older, or at least 80% of the units are occupied by one or more persons 55 years of age or older and adheres to a policy that demonstrates an intent to house persons who are 55 or older. The Florida Commission on Human Relations maintains a registry of 55 and older communities at http://fchr.state.fl.us. Select Directory of 55 plus housing communities from the menu. You can search the directory by county, city, name, or address. Non-protected classes. If a group is not protected under the Fair Housing Act, discrimination against that group is not illegal. A landlord, for example, may place a newspaper advertisement stating that a residential property will be rented only to non-smokers or to those without pets. The landlord's refusal to rent residential property to a potential tenant based solely on the fact that the prospect is a smoker or owns a pet is not a violation of the Fair Housing Act. Excluding non-protected groups of people from renting property may be a poor business decision, but it is not a violation of the Fair Housing Act. Equal housing opportunity poster. The Fair Housing Act requires the use of an equal opportunity poster. The poster features the Equal Housing logo and a statement pledging adherence to the Fair Housing Act. The poster, see Equal Housing Opportunity Poster, is available from the Department of Housing and Urban Development (HUD). The poster must be displayed at real estate brokerage offices and other businesses involved in the housing industry. In the event a discrimination complaint is made against a broker, HUD considers failure to prominently display the Equal Housing Opportunity Poster in the broker's place of business as evidence of discrimination. Telephone Consumer Protection Act, TCPA. A telephone solicitation is defined as the initiation of a telephone call for the purpose of encouraging the purchase of, or investment in, property, goods, or services. The Telephone Consumer Protection Act, TCPA, established a national do not call registry for consumers who wish to avoid telemarketing calls. Consumers at no charge may request to be on the list. Telemarketers must first search the national registry before making telemarketing calls, unless the recipient has given prior express consent. The TCPA and Federal Communications Commission (FCC) rules require the following. Restricts solicitors from making calls to residences to the hours of 8 a.m. to 9 p.m. requires solicitors to maintain a company-specific do not call list of consumers who have asked not to be called, requires solicitors to honor the National Do No Call Registry, requires solicitors to provide their name, the name of the person or entity on whose behalf the call is being made, and a telephone number or address at which the person or entity may be contacted, prohibits solicitations using an artificial voice or a recording to residences, prohibits any call made using automated telephone equipment, prohibits unsolicited advertising. Faxes. The federal law covers both interstate, between states, and intrastate, within state, telemarketing calls. The law exempts 1. Political solicitations, 2. Telephone surveys. Callers purporting to take a survey but who also offer to sell goods or services must comply with the Do Not Call registry. And 3. Charitable solicitations. The Do Not Call rules apply to residential calls, not business-to-business calls. Violators of the Do Not Call registry can be fined up to $16,000 for each illegal call. Pre-recorded telemarketing calls, robocalls, or unsolicited pre-recorded telemarketing calls to landline home telephones, and all auto-dialed or pre-recorded calls or text messages to wireless numbers. FCC rules ban text messages sent to mobile phones using an auto-dialer unless the consumer previously gave consent to receive the message. The ban applies even if the consumer has not placed the mobile phone number on the National Do Not Call list. FCC rules require a business to obtain written consent, on paper or through electronic means, before it may make a pre-recorded telemarketing call to a residential phone number or make an auto-dialed or pre-recorded telemarketing call or text to a wireless number. Robocalls made to any phone number for the purpose of political solicitation are legal. State regulation. Florida's telemarketing law is administered through the Department of Agriculture and Consumer Services, FDACS. The FDACS maintains a no-sales solicitation calls registry for consumers who do not want to receive sales calls or texts on their residential and mobile telephones. Consumers may apply online to be included on the state registry. The Florida statute mandates that the FDACS include in the Florida registry listings from the National Registry that relate to Florida. Violators of Florida's Telemarketing Act may be fined $10,000 per call. A major difference between the state and federal telemarketing laws is that the Florida law exempts real estate licensees who solicit listings in response to a for sale yard sign or advertisement placed by a for sale by owner, FSBO seller. See Figure 2.6. However, the federal law does not exempt calls to FSBO sellers for the purpose of solicitation whose numbers are on the National Registry. If a phone number is on both the National and the State Registry, the FCC ruled that real estate licensees must comply with the National Registry, regardless of the Florida exemption. Florida's law, which provides an exemption for real estate licensees who wish to solicit listings from FSBOs, is considered less restrictive and is therefore preempted by the federal law. The federal law provides for the following exceptions. A real estate licensee representing a potential buyer may call the FSBO seller, but only if the licensee has an actual buyer interested in the property and for the purposes of negotiating a sale. A licensee may contact individuals with whom the licensee has had an established business relationship, even if those customers' numbers are on the National Registry. For example, the company that previously listed a property may contact the former customer to solicit new business for up to 18 months after the business transaction has been concluded. Licensees may contact a customer for 3 months after a business inquiry or application, such as a customer who registered at an open house or a FSBO seller who requested information from a sales associate. If a real estate licensee calls a FSBO or an expired listing under the exceptions listed above and the homeowner requests not to be called, the licensee must comply. Telemarketers must state their names, the business name, and the business telephone number. Telemarketers may not block their phone numbers. Businesses that use telemarketing must develop and adhere to written procedures regarding the firm's calling policies. Businesses must advise and train their personnel and independent contractors engaged in telephone solicitation regarding do not call list maintenance and procedures. Real estate companies that wish to use telemarketing in their business strategy must obtain a list of phone numbers in the registry. The list is organized by area code and it is available from the Federal Trade Commission (FTC). There is no charge for the first 5 area codes. A fee is charged for additional area codes. Licensees must search the National Registry at least quarterly and delete from their call lists the phone numbers of consumers who have registered. Consumers can file a complaint with the FCC against a telemarketer who violates the law. Email advertising. The CAN-SPAM Act is a federal law that sets national standards for commercial emails. The law applies to any business that uses email in its marketing program. FCC rules restrict sending unwanted commercial email messages, spam, to computers. All commercial email messages must allow the consumer to opt out of receiving future messages. Senders have 10 business days to honor requests to opt out. To be CAN-SPAM compliant when sending email messages, the sender must do the following: include a valid physical postal address in every email, provide a clear and obvious way to opt out of every email, and honor the unsubscribe request within 10 business days. Use clear from, to, and reply to language that accurately reflects the person or business sending the message, as well as the domain name and email address. Fax solicitations. The Junk Fax Prevention Act and FCC rules mandate that it is unlawful to send unsolicited advertisements to a residential or business fax machine without the recipient's prior express invitation or permission. Faxes that contain an unsolicited advertisement must include an opt-out notice. All faxes, whether unsolicited or solicited and whether sent by fax machine or computer, must include the following: date and time the fax is sent, registered name of the company sending the fax, phone number of the company sending the fax or of the sending fax machine's phone number. To learn more about the National Do Not Call Registry, visit the FCC website at www.donotcall.governor.
Summary of important points, Unit 2.
Summary of important points. Types of business entities that may register as a brokerage entity include the following: sole proprietorship, general partnership, limited partnership, limited liability partnership, corporation, and limited liability company. A sole proprietorship is a business owned by one person. A real estate brokerage. Sole proprietorship exists when the broker is the only owner. Sole proprietors are personally liable for the business losses as well as the debts and torts, negligent acts arising from breach of duty created by law, of sales associates and others working for the broker when acting within the scope of their duties. A general partnership is an association of two or more persons for the purpose of jointly conducting a business. General partners are agents for each other. One partner entering into an agreement binds the other partners to the agreement. Florida general partnerships are not subject to direct taxation. General partnerships feature pass-through treatment for federal income tax purposes. At least one partner must be an active real estate broker in a general partnership real estate brokerage. Partners who will deal with the public and perform services of real estate must be licensed as active brokers. A limited partnership is composed of both general partners and limited partners. Limited partners invest cash and may not participate in management. Limited partners have limited liability. All general partners who expect to perform real estate brokerage services on behalf of the limited partnership must be licensed as active brokers. Sales associates and broker associates may not be general partners in a real estate brokerage limited partnership. However, they may be limited partners. A corporation is an artificial person or legal entity created by law, consisting of one or more individuals. At least one of the corporation's officers or directors must be licensed as an active broker. Active Florida brokers, inactive Florida brokers, and unlicensed people may serve as officers and directors of a real estate brokerage. However, officers and directors who deal with the public and perform services of real estate must be licensed as active brokers. Sales associates and broker associates may not be officers or directors in real estate brokerage corporations. Sales associates and broker associates may be shareholders of a real estate brokerage corporation. An ostensible partnership, or quasi-partnership, exists where there is no real partnership, but the parties act or do business in such a manner that the public assumes that a partnership exists. Ostensible partnerships are considered fraudulent and deceitful, and any licensees who operate as ostensible partners are subject to discipline. A trade name is a business name other than the legal name of the person doing business. A broker or brokerage entity may use a trade name after the name is registered with the DBPR. Fictitious name refers to the name registered with the Department of State. To have an active status, a real estate broker is required to open an office and register it with the DBPR. If a broker desires to conduct business from additional locations, the broker must register each additional location as a branch office and pay the appropriate registration fees. Registrations issued to branch offices are not transferable to another location. The brokerage office sign must contain 1. The trade name, if applicable, 2. The broker's name, and 3. The words licensed, or lic real, estate broker if desired. The names of the sales associates and broker associates may be added below the broker's name. S. provided the appropriate title, sales associate or broker associate, appears after their name. A line or a space must separate the broker's names from the associates' names. The Americans with Disabilities Act, ADA, prohibits discrimination in places of public accommodation and commercial facilities such as hotels and real estate offices. All advertising must be in the name of the brokerage and under the supervision of the broker. Licensees who include their personal name in advertisements must use their last name as registered with the DBPR. Blind advertising fails to disclose the license name of the brokerage firm and provides only a post office box number, telephone number, and/or street address. Point of contact information refers to the information provided on the internet for contacting a brokerage firm or individual licensee, including mailing addresses, physical street addresses, email addresses, telephone numbers, and fax telephone numbers. The brokerage firm name must be above, below, or adjacent to point of contact information. Failing to provide accurate and current rental information for a fee is a first-degree misdemeanor. The penalty for a first-degree misdemeanor is the fine of not more than $1,000 and/or up to 1 year in jail. A telephone solicitation is a telephone call placed for the purpose of encouraging the purchase of, or investment in, property, goods, or services. Telemarketers, including real estate licensees, must search the National Do Not Call registry before making telemarketing calls. Violators of the Federal Telephone Consumer Protection Act may be fined up to $16,000 per call. The penalty for violating Florida's Telemarketing Act is $10,000 per call.